Day it is. We have a tremendous stream planned ahead. We're talking about the great redistricting war that is unfolding all across America. Now, Reuters and others are acknowledging the GOP is winning. We're seeing what some of the fallout is in the aftermath after the Supreme Court issued the Louisiana versus Calais case, and the states are jockeying amongst themselves to deal with the new ruling, and we're starting to see some of the numbers come in. R+1, D-1, D+1, R+5. All of it is happening, and we've got the latest updates, including the decisions that are now out in Alabama and what Louisiana is up to for Team Red. Then we'll talk about the Postal Service. Remember that yesterday on the show, we had a District of Columbia judge called Carl Nichols issue a very interesting decision saying that the Democratic entities like the DSCC, the NAACP, and the United Latinxo Citizens, they lost their attempt to get an injunction to stop President Trump's executive order, which would revamp some of the election integrity mechanisms, including the U.S. Postal Service and the state ballots or the state lists or the federal list interfacing with the states. We're going to talk about it. We got new proposed rules released today from the Postal Service now that the injunction is no longer going to be valid. And we'll take a look at what the mechanics are on that. How will the mail change as they relate to the mail-in ballots? Will there be barcodes? Will there be new outer envelopes? Can we track these things to prevent the ballot harvesting, the drop box abuse, and more? Then we've got another bad judge. Earlier this week, we saw that the Marco Polo USA crew and Garrett Ziegler, they identified a very problematic judge in Georgia, a federal judge who was making bang bang with a popo in her office in earshot of her entire staff. Her law clerks were like, please stop, it's earmuff time. And now there's another judge, this one right nearby in the South, who was making some very racist comments and sounds like a horrific person. We've got a 120-page complaint that just unloads on her, a litany of abuses coming out of her office, and she has been suspended. So we'll learn who that is and see just how bad the depravity ultimately was. Although no allegations of her making bang bang with anybody, but maybe that was happening too. So we got a great stream plan. Thank you for joining us. I hope that your week has been outstanding. And of course, today is the always amazing Friday. We're happy we're here, but we've got business to attend to and we're not done yet. So let's get into it as soon as we confirm all of the tubes and the cables have connected themselves appropriately. Sometimes they don't happen and they're not working, but it looks like we're here. What a beautiful day. It's all flying around across the interwebs. That means we can go ahead and get started. So let's do it, shall we? Well, of course, the internet's working, but as per usual, it's not always all functional. So let's just fix this right here and then fix this right here. And now this is where we want to start with the headline from Reuters. Republicans winning the great redistricting war. Now, Reuters even acknowledging this, and they've assembled for us a very convenient list showing R+ numbers and Democrats minus numbers in a compendium of the various wins. We've also got a big decision out of Alabama. You can see this one. The NAACP sued and said, we don't like your new maps because they're a little bit too racist. But the 11th Circuit came down on this one and issued a nice ruling that we'll take a look at. We've got updates on Louisiana and more, and we're going to get into all of it. But here's the roundup. The Reuters article explaining, much to the chagrin of the left, that the Republicans are winning the war over the U.S. Congressional redistricting, state by state, chipping away at what the Democrats had, which was an infrastructural advantage. We know that they were exploiting Section 2 of the Voting Rights Act in order to say that in order to prevent being racist, we have to be a little bit racist. We have to treat groups of people by the color of their skin, not the content of their vote, and bundle them up into separate but equal districts that were majority minority. Then we got the Supreme Court decision in Louisiana versus Calais, which dropped and said, we're not doing that anymore. We don't cross people into boxes and then assemble them into certain locations on a hypothetical bus. So now, in the aftermath of that historic ruling, we see the states jockeying and bandying about to adopt those rules and to redistrict aggressively. And state by state, the Republicans are winning because the Democrats had already perverted that rule for their own advantage. Now, here's the latest from Reuters. They say the political war began some time ago, even before Calais came down. Texas Republicans responded, then California Democrats responded, and it was about a draw. Things were about even Stevens across the board. But then we had the Supreme Court rulings come down, and now Republicans appear poised to end the cycle because we're getting close to some deadlines. We're getting close to voting starting in primaries all across the country. And so you kind of have a clock on this thing. They say now going to increase their edge by as many as 10 seats nationwide, which is a good development for the right. Now, Democrats need to flip only 3 Republican-held seats, and so we don't want to get too carried away here in order for them to win a majority. That means, though, they've got a little bit of a taller battle ahead of them. And it's not going to be a foregone conclusion, as it usually is in midterm campaigns. You have a president comes in. Almost always, there's a couple of exceptions in the rules over American history where the party in power keeps the House. Usually it kind of balances out, but maybe it won't happen this time. Here's how it has unfolded. In Tennessee, Republicans +1. Lawmakers back in Tennessee on May 7th approved a new congressional map that dismantles the majority black district, which was created for black people. Remember, they called them majority minority districts. In other words, race went into the equation. They weren't drawing the maps based on partisanship, which is allowed. The Supreme Court said you can do that. But they were literally saying, in order to comply with the law, we have to be not racist by being racist by drawing race-based maps. Can't do that anymore. So now the current representative in one of those seats, called Steve Cohen, a Democrat, said, I'm out. South Carolina, though, bunch of weenies. That effort failed. Just this week, they in South Carolina, shame on you, rejected a new map that would have taken apart one of the seats by Jim Clyburn. If you know who he is, he's about as interesting as a can of paint. Despite pressure from the White House, Republicans broke ranks, and so presumably they'll be primaried and booted out like has happened in other states. But Republicans control 6 districts there. Alabama. This one is still under litigation. We've got a new decision from the 11th Circuit, but this will probably go up to SCOTUS like some of the others. A panel of 3 judges, we're going to get to this next, blocked Alabama from advancing a new map that would eliminate one. Republicans have appealed that order to the Supreme Court. We just got, I think after this article came down, another decision from the 11th Circuit. And so we're still going to be battling in Alabama. But this one looks like it's going to go in favor of the right. So that 10 count is probably going to go up even a little bit more. Texas, 5 seats. SCOTUS cleared the way in early December for a new Republican-backed map that targets 5 Democrat seats. And the court's decision overturned a lower decision that said, you can't do that. We have to have racist maps. And of course, the Supreme Court said, not anymore, we're not, because this is America. We don't do that. Texas Governor Greg Abbott signed the map into law. And now those have flipped. Republicans already control 25 of the 38, and now they're picking up 5 in that one. Florida, 4 seats. Soon as Calais came down, Ron DeSantis and their crew, they drew a new map. They flipped Democrat-held seats, called into session a special legislative session, did it legally, unlike the CIA governor of Virginia called Abigail Spanberger. And this one is going to flip up to 4 seats, presuming, of course, that the Republicans win those seats. Missouri got 1 seat. Republican Governor Mike Kehoe signed the new map into law that nuked a Democrat-held seat in Kansas City. Now they've got 7 out of 8 over there. In Ohio, they're up 2 seats. A quirk in state law required a new map for 2026 because the previous one was approved with no Democrat votes. So they reinstituted it, and the Democrats unanimously approved, 5 Republicans and 2 Democrats, unanimously approved a compromise map that boosted the Republican chances of flipping 2 Democrat-held seats, but did not go as far as some other ones. Republicans got 10 of the 15 there, picking up 2 more in Ohio. North Carolina, +1 for Team Red. The state legislature there and their Republican majority approved a new map in October that's going to flip a Dem seat into the red seat. Republicans already control 11 of the 14 seats, despite its status as a divided swing state. Under state law, Governor Josh Stein had no say in the process. Let's go. Then in Louisiana, another one. Jeff Landry suspended the May 16th primary for the House. They said, sorry, Louisiana versus Calais just came down. And now your racist maps are no longer valid. So the racial gerrymander that once again is carving people up by the color of their skin is invalid because it's discriminatory. And now passed a new map on May 28th, just got signed into law. We've got some follow-up on that coming up as well. Now in Indiana, they failed and did not do that. Republicans still control 7 of the 9. Kansas, same thing. What's going on over there in Kansas? Republicans in Kansas abandoned an effort. They said there's not enough support to overcome a veto from the Democrat governor. They already hold 3 of the 4 seats over there. So picking up red seats across the board, and they're just playing the same game that the Democrats play. Look at the New England states. They're blue through and through. They don't afford any majority minority districts for like white conservative Christians at all. They just say, nope, sorry, Republicans, eat it. We're not going to give you any representation at all, even though in some of these states, 30 to 40, maybe 45% of the constituency there actually votes Republican, but they've got 0 seats in the House in many of those New England states. Now let's go to the Democrat side and their tally. California, they already are gerrymandered to hell, and they decided to turn the lever a little bit more. They picked up 5 seats there. Now in Virginia, we've got a temporary victory here, might be fleeting because they'll put this thing on the ballot the next time. Virginia voters approved an illegal amendment to their constitution, and the state Supreme Court, though, threw out the results because it was illegal. They said that the dismissal of the new amendment, which would have flipped it and basically given 4 seats to the left, was not valid. Switching it from a 6-5 to a 10-1 failed. They lost. They appealed it to the Supreme Court of the United States. SCOTUS said, it's not our business. It's your state constitution. It's your state issues, and your state Supreme Court had the final say. In Utah, they picked up 1 seat, and this is wild. A state judge threw out a map that was going to flip one of the state's 4 seats to the Democrats. And, 4 Republican seats, 2 Democrats. So they've got 1 seat out there. So they picked up 1 there. Maryland, they stalled out. They advanced a new map, and they opposed the bill, but they may come back in 2028. In New York, they got blocked by the court, but they already hold 19 of the 26 seats. They were going to try to gerrymander it even harder. And so all said and done at this current moment, after a lot of this is fleshed out, Republicans are up about 10, may go above that. But it is winning across the board, and the Democrats are not happy about this at all. Mark Elias and the rest of them watching their dreams of institutional, structured, infrastructural advantages now losing because they spent the last how many generations exploiting the Voting Rights Act to say, in order to not be racist, you have to give us an advantage. And it's the most stereotypical garbage you've ever seen in your life. They say that apparently, according to their ideology and theology, that all black people will vote the same and be Democratic. So we have to bundle them together. All Hispanic people will do the same, like in California. In fact, in many of their redistricting efforts, when the people would come in and testify about how they drew the maps, they would say that explicitly. In California, we just covered it yesterday. They said, we started by saying, how can we put the Hispanics together? Or in their vernacular, the Latinxes. So nice wins across the board. Reuters is recognizing it, and the time to undo this before the midterms is now fleeting and evaporating right in front of their very eyes. So hopefully this all continues to hold and the pattern continues, because this is not, in my opinion, a seizure of power. It's undoing an illegal advantage that they created for themselves. Before the game was even starting, they had already drawn maps that was to their benefit, exploiting the law, saying that it was anti-discrimination to draw maps this way, when in fact it was discriminatory because they were using the color of a person's skin in order to dictate where they vote and how they vote, which of course is racist. So we also see out of Alabama, this case has been percolating, and we now have another decision that just dropped down, not a long order, from the 11th Circuit as it relates to Alabama. And we had the NAACP, we had a guy called Evan Milligan, we had Greater Birmingham Ministries, all suing the Secretary of State for Alabama to say, you can't use your new maps because your new maps are still racist. And to pause on this, we see that when it comes to Calais, the Supreme Court decision, they said that you can draw maps in a partisan fashion. Somebody's got to draw the maps. Partisanship is perfectly acceptable. If the legislature and the governor are partisans, then they can approve these maps that are drawn to give red team advantages or give blue team advantages. They're not going to undo all of those things. Now, in that same matter, they said that you still can draw racist maps, and those are still illegal. If you draw them in order to create a majority-minority district and use race to give the Democrats an advantage, that would be illegal. And they reversed that. But the Republicans, for example, if they were drawing a racist map, if they were drawing maps to say, oh, we're going to just, not give black people, like that's the argument, any voting power by debundling them and sending them out into conservative districts, and that's the reason for the map, that is still racist too, right? It works both ways, and they can't do that either. But what we're seeing is it's partisan that is really winning the day here. And if you are making allegations that both things are happening, that it's partisan, but it's also racist, then you have to disentangle the two. And you have to show there really was no partisan justification for drawing the map at all, and that the racism basically superseded the intention of the map. Once you delineate and distinguish the two, then you can make your argument this is a racist map. And essentially, the lower level courts in Alabama found that. They said, all right, it's not partisan. You're trying to dispossess black people of a vote. And so we've been battling over this for a while. Now we're in the 11th Circuit Court of Appeals. They've also taken this up to the Supreme Court, but at the moment, that's, I think, on pause by Justice Clarence Thomas, who received the initial request. And he's saying, let's let this thing, kind of mature through the Court of Appeals. And that's where we're at right now. So the 11th Circuit is writing the following. They say, all right, look, in 2021, based on new census data, the Alabama legislature redrew the boundary lines for its 35 Senate districts. And in response, plaintiffs sued to stop Wes Allen, the Secretary of State, from holding elections under the 2021 map because they said back in 21, before Calais came down, it was a violation of the Voting Rights Act. Now, after trial, the lower level court found for the plaintiffs. They said they enjoined the secretary. So the legislature came back down and the secretary were all in the middle of this fight. And they said, you can't use this map. This map is too racist. You cannot conduct any Senate elections according to the 2021 map. And you have to instead, saying imposed its own boundary lines. The lower level court said, I'm going to draw the map now, and ordered the secretary to administer the upcoming state Senate elections using a new map. Now, that's what the secretary did on May 19th. Then the secretary now appeals those injunctions, and he applies to stay them pending appeal. Okay, so he starts using the new maps. Then he says, we don't need to use those new maps. Now, first, the secretary argues that says, hey, things changed. I was ordered to use a new map, but then SCOTUS came down with Louisiana versus Calais. And he made a strong showing that we should vacate the injunction. The lower court said, you are injuncted, you're ordered to do this thing. Then the Supreme Court comes back down and says, actually, how they were applying that rule is bad. So he's saying, vacate that, right? Don't make me do this anymore. He's made a strong showing, says the 11th Circuit. The Supreme Court in the last few weeks has vacated similar lower level district court injunctions and remanded, saying you can't do this if it's a racist map. And so citing those from the Supreme Court in this case and in this case, and the cases are remanded back down. Now, as we continue, we see, if anything, the issues in this case more closely match the issues in Calais. And when briefing is done, we will likely do as the Supreme Court has done. We're probably going to do the same thing that they've done before. Now, the dissent here focuses on whether the Secretary has shown a strong likelihood that the 2021 map violates Section 2, which is that key provision of the Voting Rights Act that says you can't discriminate. But this answers the wrong question. The question for us is not whether the evidence supports the NAACP's claim. We don't look back at the merits of the underlying lawsuit. Instead, for a stay, we look to whether the party seeking relief is going to win on appeal, citing some other cases there. This weighs heavily, in fact, in the favor of a stay. Now, so does the irreparable harm factor. Now, the lower level court's injunction irreparably harmed the state because they prohibit it from conducting the Senate elections under the 2021 map that was approved by the people and the legislature. The court stepped in and said, I'm going to draw a new map. You can't use your map that the people voted on. Now, as the Supreme Court has explained, the inability to enforce its duly accepted plans clearly inflicts irreparable harm, citing a bunch more cases here and this whole paragraph. Now, the dissent says that the Secretary's delay in seeking to stay those injunctions shows there is no harm. Like, they've been harmed for all these years. And so now they're claiming harm. But there was no delay. The Secretary moved for a stay almost immediately after the district court imposed them. When that motion was denied, the Secretary almost immediately sought a stay in front of us. Now, after the Supreme Court decided, the Secretary's back and moved to stay it again pending the appeal. Now, this time, we punted to the district court, which denied relief. The Secretary then moved another time for a stay, and we're not sure what else the Secretary could have done. Certainly, he did more than the moving party in this case. And there, the moving party waited 5 months before seeking any equitable relief from the court. So here, the Secretary sought stay no more than a week after the injunctions. And third, staying the injunctions will not substantially injure the plaintiffs because they have not shown that they're entitled to the injunctions. The plaintiffs have not shown that they're going to succeed on their Section 2 claim that you have to draw a map in a majority minority district after Calais. In fact, they can't. At best, they say they deserve a chance to fully address the impact of the new decision. And the dissent says it's far from clear that the lower conclusions were erroneous, but far from clear is not a substantial injury that warrants an ongoing injunction. And finally, the public interest lies in electing the public representatives with the public's chosen map over the new one that was drawn by a judge and a district court. So let the people decide how they draw their maps, not some unelected judge in a black robe who says, I know better than you. So having considered the four factors, including the two most critical ones, they weigh in favor of a stay. So the injunction to use the judicial map can be paused and the 2021 maps can go into effect, which are in favor of the Republicans. Now, for that reason, we grant the Secretary's motion and stay the judge's injunctions pending issuance of the mandate of these appeals. And one judge called Abudu is very upset about this. So that's the full dissent from Abudu. And he's saying, you know, basically, we think that they may win or that it's a racist map and whatever. But Alabama now wins that at the 11th Circuit, and it's going to continue to percolate up through and to the Supreme Court, I'm sure. I'm sure that the NAACP and the Birmingham Ministries and Evan Milligan and LaQuisha are all going to be appealing this up to SCOTUS. But their claims, from our reading, are without merit. You can no longer draw majority-minority districts on the basis of race. Now, if they want to make the argument later that the maps are not partisan, they are in fact racist, they can make that claim under Calais, but it's not appropriate to stay the lower level court's decision to use their maps versus the people's maps. And so the people's maps come on back in. So another big win out of the 11th Circuit, and they're celebrating that over in Alabama. Now, the same thing is happening in Louisiana just today. Louisiana lawmakers passed the new map to give the GOP an additional House seat. And we have some excerpts from what went down in their legislature. They now have gotten this done, passing it today to pick up a Republican seat while leaving the state with, and they always, this actually is a pretty decent headline here from CNN. Most of the other headlines I saw in this as I was queuing this up were saying Louisiana disenfranchises black people, essentially. Every headline across the country today. Louisiana nukes the only majority black districts. Like, okay, guys. So you're still going to do this after everything? You're still just going to ratchet up? Everything is racist? Like, that's your whole shtick? You need to come up with something new. So they now passed a new map. Approval came 1 month after the Supreme Court struck down the current map, called it illegal, called it a racial gerrymander, revisited the Voting Rights Act, intensifying a national redistricting war. Louisiana Republicans had considered drawing a map that gave them a shot at winning all 6 seats, but that would have required adding more black voters to Republican districts, and they say it could have backfired. Some Republicans said a 5-1 map better protects Mike Johnson. Now, Jeff Landry is signing that, and I think has signed that into law, or will be shortly. Several other Republican southern states are also seizing upon this, and so far, Republicans, according to CNN, are winning. But that doesn't necessarily mean that they're going to win the House. It's so close. They think they could gain as many as 14 seats, while Democrats think they could gain 6 seats from California and Utah. In Louisiana, Republicans hold 4 of the 6 seats. Now that's going to flip. They're going to get another one. Landry, the governor, postponed the primary scheduled for the 16th because they were using illegal maps. And the new map now redraws another Democrats' district out, intermingling it with white communities in Baton Rouge and southern Louisiana, and so he's probably going to be gone. Now, lawsuits will continue to pile in. Democrats say the map is a racial gerrymander because it packs black voters into a single district, and they can make that argument. But they're going to have to show that it's predominantly that it's not for partisan purposes, that it's basically essentially a racist map in the other direction, while the Democrats are bundling black voters together because they say, you guys all are the same. They're saying Republicans, if they try to also, cordon people off according to race, that could also be illegal. Florida passed new maps. Tennessee passed new maps. Alabama is still litigating, but the 11th Circuit seems to indicate where this is going. And after that decision, I'm not sure SCOTUS needs to do anything with it. Just say, nope, the old map can come back from 2021, not the judge's map, and the election can proceed accordingly. And then eventually the whole thing may become moot once the votes are cast. But it will continue on. There's going to be a lot of litigation on this. Of course, we're going to keep our eye on it. Here's more about what happened from WVUE Fox out in New Orleans, in Louisiana, with some clips from what went down in the legislature and from some Louisiana congresspeople at the state level. And here is this clip coming up right now. Not full screen.
Makeup doesn't matter. What matters is politics.
Louisiana House lawmakers passed a congressional map tonight redrawn along party lines. The map includes 1 minority district and secures Republican majorities in the remaining 5 districts.
Nice.
Jennifer Crockett reports the map will divide one parish into multiple districts.
Members, vote your machines.
In a party line vote Thursday,
66 yeas, 35 nays.
Louisiana's House inks what will likely be the state's next congressional map.
This does look like it is going to be the final map.
Dillard University political analyst Dr.
Nice.
Robert Collins says the bill will likely sail through Senate concurrence and earn Governor Jeff Landry's signature in the coming days.
I think the cake is already baked, that this will be sent to the governor for his approval.
Representative Kyle Green is one of several Democrats who spent nearly 8 hours Thursday testifying against dropping one of the state's 2 minority districts. This spring, the Supreme Court ruled the state relied too heavily on race in its current map, leading to this version. But Louisiana's Legislative Black Caucus Chair, Representative Edmund Jordan, says this map widely favors white Republicans.
Truth is, after y'all vote on this today, y'all can walk in here and nothing changes for you. This is your surplus. That's what this is. For us, this is out of our need. Our lives changed dramatically.
We drew the map to improve Republican strength. In Calais, the Supreme Court clearly says courts must treat partisan advantage like any other race-neutral aim, a constitutionally permissible criteria that states may rely on as desired.
Collins says in the South, separating race from party is nearly impossible.
The majority of black voters tend to vote Democrat. The majority of white voters tend to vote Republican. So that's sort of the conundrum that we're in the South, is that, you know, the Black Caucus has always argued, you say it's a political gerrymander, it's a partisan gerrymander, but it's a racial gerrymander, because in the South you cannot separate race from party.
Democrats said this map will be challenged in court, but Collins is doubtful the court will make more changes after its most recent decision favored representation based on political party over race.
So this is the map that we're looking at now. Some of these lines may move slightly based on the Senate concurring with the House's amendments, but you can see Tangipahoa, that's split into 2 districts. You can see the majority of the Fox 8 viewing area remains the same. That is Scalise's district, Troy Carter's district, but you can see up along the North Shore and part of the river parishes, and again Tangipahoa parishes, you might see some changes. The big changes, though, Baton Rouge is now carved into multiple districts. We'll have to wait until August to see who will run for these new district seats in November.
All right, so big wins out of Louisiana, Alabama. We've got Tennessee, we've got Texas, and many more. And of course, the battle will continue. It is not going to stop. The Democrats will not let this little grasp on their power evaporate lightly. And so we'll keep our eye on this one. But as it stands, even according to Reuters, according to CNN, the GOP is winning the redistricting war. Republicans up +10. That number might go up even more. Thank you for joining us as we keep our eye on this one. Now, speaking of election rules, we've got more happening here. And this one has the right people very, very nervous. Democrats freaking out over the new U.S. Postal Service mail-in ballot rules. This is only a proposal pursuant to President Trump's executive order, which he initiated, saying we need to secure our elections, and the federal government is not going to stand by while the states continue to ignore these efforts. 2 main components of that executive order were, 1, the federal government will create their own lists. If the state don't want to maintain their lists, if they want to have dead people on the ballots, voter rolls, if they want to have people who've moved, who have left the state on the list still, if they want people born in the 1800s still getting ballots and not maintain them, then the feds will make their own list. They'll share them with the states. They can use them if they want to. It's not mandatory. But since the federal government maintains the Postal Service, if you want to mail an absentee ballot or a mail-in ballot using the federal mail, they're going to check it. They're not going to facilitate fraud and just mail illegal ballots using their systems. So now they have proposed new rules, and a judge out of Washington, D.C. has now also said that the lawsuit that is attempting to prevent this from even being contemplated out of the White House lose. NAACP, the Latinxo United Citizens, and other individuals now failing to secure their injunction. And so the Postal Service dropped today the new proposal. We'll take a look at the details. We have the PDF here queued up to get into the nitty gritty on this, but the right people are very nervous about this. And Mark Elias, who we talk a lot about here, Democrat super election lawyer, has said the Postal Service said in a new rule published today, it's drawing up plans to radically crack down on mail-in voting. That's right. By sending ballots only to voters who are registered with the federal government. And that's not accurate because you have to be on the list, but the states can amend the lists. And if there's a problem with the list, update them, add your residents, add your citizens to the list. But it's not going to be just a maddening free-for-all where everybody can just mail ballots to whomever they want, whenever they want, however they want, harvest them, put them in drop boxes. We want barcodes. We want official envelopes. We really don't even want a lot of mail-in balloting if we can help it, but the government at the Postal Service level will be monitoring these things. And here's what he writes in his article over at Democracy Docket. He says, Postal Service moving forward with Trump's attack on mail voting. And this gives away the game. If Mark Elias is ultra in favor of mail-in voting, that's because he believes it gives his party an advantage. Mega anti-Trumper. Remember, Mark Elias was the guy who was Hillary Clinton's campaign lawyer and helped facilitate Michael Sussman, who was also at the same law firm, going over to meet with the FBI to shill the Russia collusion hoax that involved the Christopher Steele dossier, which was campaign propaganda. Hillary had a problem with her emails. Mark Elias has been in the middle of election shenanigans since the very beginning. So if he's nervous about this, that's tremendous news. That means we're winning bigly. So the article explains right here that the new rules are being proposed, and it would require states to provide voter-level data on mail-in ballots in federal elections. We're not managing your elections, states. Don't freak out. Don't cry. It's not a total takeover by dictator Trump. All it is, if you want to use the mail, we're going to be collecting mail from people who legitimately are ineligible to vote. It's like certified mail. We want to make sure it gets to the right address, gets to the right location. We're not going to ship ballots from the state ballot printer to a bunch of people who are not entitled to them. We're going to secure it. This comes in the aftermath of Trump's executive order. The proposal would require states to submit to the Postal Service the names and addresses of voters who are actually getting the mail-in or absentee ballots, along with unique barcodes tied to each voter's outbound and return ballot envelopes. Postal Service said the rule would help determine how many ballots were mailed and allow officials to compare that figure with the number of ballots returned and to detect other potential issues for further investigation. And we just saw in Maryland, 500,000 ballots went out to the wrong people. Their lists are broken, their systems are broken, and they don't want anybody going in and checking the list. Harmeet Dillon in the Civil Division is suing a number of states, like half of them. The red states are compliant. The red states say, here's our list. Let me show you them. Are there problems? Because they want voter integrity. The left doesn't. They want voter enfranchisement, is their little propaganda term. They want people to participate in democracy, even if those people are not citizens. They're even contemplating that in California. So this would apply to general, special, runoff elections, but not primaries or ballots that are sent to military or overseas voters. And so this would be a proposal with barcodes, a reporting system, and more. And they would use their own data to create state-specific lists. There would be a federal ballot mail portal. The proposal would also allow the U.S. Postal Service return outbound federal ballot mailings that do not meet the standards to not go out. The state would still control who is eligible to vote. The Constitution designates that states run their elections. Of course they do. But like the U.S. Postal Service won't ship crack cocaine through the mail if they can help it, they're not going to ship fraudulent ballots. Federal judge, as we talked about on the show yesterday, declined to issue an injunction that would block all of this from happening. And now the judge has opened the door to allow this thought process to continue on. And this is just a proposal that has the right people very, very nervous. And here's what it looks like. So you can see this one dropped today. It is going to be published days from now. And it's just a proposed rule. Okay, lawsuits are going to start to fly again. But the Postal Service is proposing to amend the rules and the mail manual about the transmission of mail-in or absentee ballots for federal elections. Now, you can have comments about this. You can object to it. You can say, this is going to cost a lot of money. This is going to make it more difficult to whatever. This is going to disenfranchise, whatever. Mail or deliver your comments, okay? Mark Elias, you can send them in to this address right here on Font Plaza in Washington, D.C. And you can hope that the mail gets delivered. So you can also inspect everything. Here are the rules. They say, here's the background. On March 31st, Trump issued an executive order ensuring citizenship verification, which they do not want to do, and integrity in federal elections. And as we've talked about, They say this never happens ever. Illegals don't vote in elections. Well, they do, actually. We found them. They're now, some of them being charged. But just think about how overworked prosecutors' offices already are. The DOJ is scrambling for lawyers. They're out of them. And if you want to issue and start an investigation nationwide into voting fraud and actually prosecute people for it, you're going to need gobs more resources that they just don't have. And the prior administration didn't even investigate them at all. So for guys like Jake Tapper and the rest of the mainstream media to come out and say there is no widespread voter fraud, did you even look for it? The answer is no. Of course they did not. Now they're looking for it, and still they have to go back. Every single person who is a election fraudster, that's a whole new criminal case. It's a whole new case file. It needs a prosecutor. We're already overwhelmed with all of Biden's other prosecutions, many of which should just be dismissed as lost causes and start fresh. But there's not enough resources to go after hundreds of thousands of election fraudsters. So we're just going to do it procedurally now. We're just going to check as they come in to prevent the fraud rather than to prosecute the fraud after the fact. So the order discusses the importance of additional measures concerning the use of mail and mail voting in elections to facilitate enforcement of federal law, reduce the risk of fraud rather than catching it after the fact, just stop it at the outset, and help protect the integrity of our elections. Now, following the issuance of Trump's executive order, the Postal Service submitted this proposed rule to the OMB for interagency review. Subsequent to that process, the Postal Service issues now this proposed rule about the preparation of ballot mail for federal elections to facilitate the enforcement of federal law. The proposed rule would also implement best practices for Postal Service operations as they relate to ballot mail. Now, here's more. We've got legal authority to do this. 39 U.S. Code, various sections. We can govern ourselves. Congress said so. We would apply uniform standards like we do with other mail to absentee ballots and follow federal law. We have the authority to change the rules and the regulations. Congress said we're the Postal Service. And so now here's the proposed rule, since we can do this. And again, Trump's executive order didn't say break all of the laws. Say, I want you to take over state elections and find things illegal that you can do or shouldn't do, but can do anyways. He said, follow the laws, operate within the confines of the rules as they've already been established. So now they want to do this. We are proposing to add a section to the mail manual that contains the following preparation conditions when mailing ballots for elections, except that these conditions won't apply to UOCAVA ballots for overseas absentee votes. Here's what they want. This section 705 would identify new standards for the envelope design and review for outbound and return ballot envelopes. So just like you may get a certified mail that looks different than like when your mom mails you a letter, these are consistent with existing best practices. The standards would add an election mail logo, so we treat this as a little extra special, automation compatibility, placement of a uniquely serialized intelligent mail barcode on each outbound and return ballot envelope, and a mail piece design review. So we can track it, just like chain of custody in a criminal case. We don't want fraudulent chains of custody. We want to know it got sent to this address and it's coming back from that address. The mail preparation standards improve the visibility of ballots in the mail stream, and they're consistent with our current mail preparation recommendations for ballots that are in this section. We currently have the resources available too to assist with compliance, which we're going to continue to make available. An example of a resource currently provided to election officials is located at that address right there. Look it up, Mark. The election mail logo is also an important tool for mail piece visibility. It allows voters to recognize election mail as important and distinct from other mailings, and also serves to identify official mail for Postal Service employees and distinguishes it from millions of other mail pieces that are processed every day. Certain long-standing practices, including the use of, quote, extraordinary measures during the period of time before elections, are designed to return ballots from voters faster than ordinary mail processes would permit. It would also require the Postal Service to be able to visually identify them, which the election mail logo facilitates, and so incorporating that would help us identify the ballots. Now, ensuring ballot mail is also automation compatible, quote, and meets mail piece design standards means the ballot mail can be processed effectively on the mail processing equipment without unexpected complications or delays, and that relevant barcodes can be scanned as the piece moves through the mail stream. What was so problematic about this? Uniquely serialized barcodes facilitate the tracking of individual pieces of mail to and from individual voters as the barcodes are scanned on the mail processing equipment. The barcode simplifies data by consolidating information from multiple Postal Service identifiers into one comprehensive location. Scan it on the way out, you know where it's going. Pick it up, scan it on the way in, know where it's coming from. Now, this other section would also provide for an optional pre-mailing notice that states may provide to the Postal Service to facilitate the process for states to enroll individuals with the Postal Service for inclusion on these lists that we'll use to send people mail. This provision would also allow states to notify the Postal Service of their intent to use the mail for their elections. By disclosing relevant points of contact, it will allow the Postal Service to more expeditiously provide technical and other assistance in advance of the election. It will also facilitate the adoption of the new elements of ballot mailing that are proposed in this reg. And it's interesting, too, the only concern I have about the logo is now maybe the Postal Service workers can just say, mail-in ballot, shred it. Mail-in ballot, shred it. Oh, we're in this zip code. Let me just go through and just quickly identify all the mail-in ballot envelopes, all go right into the dumpster. You never know. So I'm sure there are mechanisms there to prevent that from happening inside their vehicles, but I don't actually know. Mail-in and absentee lists. This other section would establish a process by which states, including election officials, will notify the USPS of the individuals to whom they are mailing a ballot, along with the unique barcode applied to the outbound and the return mail envelope for these individuals, such that the name and the barcode of the voter will be on the list. Okay, we're not taking your ballot if you're not on the list. States, including authorized officials and their providers, may thereafter add to or modify the list up until the last day that ballots may be mailed out. So states, if you want your mail-in ballots to go out, make sure the lists are accurate. The Postal Service will provide to each state's chief election official a final state-specific mail-in and absentee list for each state, compiling the names of all enrolled individuals, along with the barcodes for every piece of mail. Now, this provision helps to facilitate federal law. The provided list, for example, will evidence how many ballots have been mailed. It will allow law enforcement officials to compare the total number of ballots that went out against the total number of ballots that were received to see and detect any potential issues further meriting further investigation, right? So, in other words, if one Postal Service worker was collecting mail-in ballots from a very red district and they go driving down the highway, throw it out, another one, throw it out, then you'd be able to reconcile the two. Okay, they would also have to not deliver them because let's say 100,000 ballots go out. We've got 50,000 ballots that come back in. Not everybody's going to vote. But then you start to get into those numbers and zoom in on it and you say, well, this is the standard returnability rate, right? 50% generally comes in. Maybe it's higher than that. I don't know. But this one zip code and this one Postal Service employee has a much lower return rate than the standard across the board. What happened there? Let's go look at it. This is accomplished by ensuring that individuals who do get a mail-in ballot are included on the list. It is also further accomplished by associating the barcodes on the envelopes with the intended recipients of the ballot mail. And as noted, these barcodes provide visibility into ballot mail transmission because of the scan data that is generated as they move through the mail. Under this proposal, states would retain control over who would or would not be able to vote by mail. States would continue to enroll them on the list. States would provide the USPS with this information via a portal. Once the state has completed their mailings, the Postal Service would then compile the information provided by them and their list. We would then not change the information provided by the state when compiling the list. Now, as noted, the Postal Service would also provide technical assistance to states when they're trying to, how does this system work? And localities about the secure submission of this data, so all of your privacy is going to be protected. Now, compliance would establish a verification standard to support this transmission. The proposed rule also implements a verification procedure for compliance with this. Prior to acceptance of an outbound piece of mail, you have to comply and be verified before we mail you anything. And the blank return ballots included within these mailings. The process of verification by USPS would confirm that a state submitted a list is consistent with the conditions laid out in the rule, and that the outbound mail and thus the blank ballot that could be returned by mail is destined to individuals on the list, again, checking the barcodes. The Postal Service would not verify whether individuals should or should not be included on the list. States will control that portion of the list. Now, we're also not proposing to apply these standards to primaries. Primary elections involve political parties. They select their nominees. We don't care about that. Those aren't federal. Only the direct election of federal officials implicate the necessity for the security here. And UOCAVA is an entirely separate law, different timings, different things, but we also welcome comments on those areas as well. Now, as required under existing law and regs, mailers must comply with all applicable postal laws and regulations governing mailability and preparation of mail. There are other non-postal mail-in laws. And so we're following the rules. So we'll take necessary steps. Also, we'll make sure we're complying with the Privacy Act. And notice about how we're going to do that is also coming soon. And we're going to continue to engage with you guys on this. We'll also continue to offer technical support. We are allowed to make rule changes. We're doing that. We're using our best practices recommendations, and we will continue to perform extraordinary measures to make sure these are delivered. That means we're going to accelerate the return ballot mail beyond our typical operations and hire a bunch of overtime people and work late hours. So we're asking for comments now. We'll publish amendments after the process is being followed. Here are some of the specifics they're saying that will ultimately go in. So they'll add in a bunch of definitions. What did they mean? They just gave us a nice summary. It includes all 50 states. An intelligent mail barcode is the same barcode that they use for other mail. And there'll be pre-mailing notices if you want. No fewer than 90 days, we'll send you a notice. Hey, you're on the list. And if you don't get a notice, then you're not on the list. And that gives you 90 days to go fix that problem so you can get on the list. All outbound mail will have a logo, will be automation compatible. We'll have a barcode with a delivery point zip code embedded into it. We'll go through a review. Anything that is being returned, same thing. Election mail logo, automation compatible with a barcode, following all design rules. And as it relates to the lists, there'll be a portal. Registration must be completed at least 2 days before the outbound federal ballot mailing. So when the printer prints the list, check the portal to make sure your list matches what's on the portal so that everybody who you want to have get a ballot will get one. All of the other changes continuing to be delineated here. It will all be verified. Mailings identified as outbound mail are verified by employees. Consistent with existing regulations, mailing of outbound mail must be entered at a facility that performs acceptance of mail functions. If you don't meet that, then there'll be other mechanisms by how this is about the quantity of mail, 200 or more pieces and more. Non-compliance, if you have mail that doesn't comply with these rules, we're not going to accept it. The authorized ballot mailer or ballot portal user must address these errors before resubmitting their ballot. And they're going to say, and this might very well be true, this disenfranchises people, right? And they're going to say, well, my vote's not going in through the mail. Well, that is because you are not on the list. So get on the list. That's the whole point. We want to make sure that you're not mailing a fraudulent ballot. It's called voter integrity. We're not just going to take mail from all over the place without any verification about where it comes from. We're not interfering with state or federal laws, and we're not altering the eligibility of anybody. It's just if the state wants to mail it, they got to make sure you're on the list. We're not managing the state lists. We're not administering the federal elections inside the states. States are fully responsible for the contents of the state's mail-in and absentee participation list. So don't have a problem with us. It's not our problem. You guys need to go fix your list, send it into the Postal Service, then we'll take your mail. Signed by an attorney called Daria Vallon. And this seems basic, man. This seems like this should have been already the rule for a very long time. So we can track where it's coming from, where it's going. We've said and made this argument here how many times? I don't know. But we should have at least faith in our elections beyond a reasonable doubt. That's a good standard for criminal law. It should be a perfect standard for our governance. Have a belief that this person got elected beyond a reasonable doubt. We don't want any doubt based in reason as to that person's validity. Otherwise, we fight over these elections for years, and we see how the riggers can go in and actually exploit the rules. So just like in a chain of custody in a criminal case, when they seize a piece of evidence, it goes from Officer A to Officer B down to the evidence locker. You mark it down. It gets impounded. When somebody takes it out to do testing, they sign a log. We pulled it out. I'm Officer so-and-so at this time, date, and location, gave it over to this forensic scientist. Then they do analysis on it. Then they put it back in. All of it signed, followed and connected, which should be the same thing in our elections. And they're going to hate this because elections are where the grift is made in the gray area, where there's tracking, there's a problem for a Democrat voter, and they want, like we saw in photos here from Washington, D.C., people getting 4, 5, 6 ballots. I've shared the anecdote multiple times about how at my home in Arizona, I got a dead guy's ballot from like 2 election cycles. I'm like, he's dead. But I got the ballot. I got it mailed over to me. No one's checking the list. No one's validating who should be on the list. These ballots are just being sprayed out in many states auto-magically. Just, you got a driver's license? Here, have a ballot. Even if you're not registered to vote. So it's just automatic registration, in other words. So this seems obvious, and there will be more lawsuits that fly in the aftermath of this, but we also don't trust the Postal Service. They're also people. We have questions about, are certain bundles being delivered? Are the Postal Service workers flipping them out the window, dumping them in the dumpster? Nobody's validating it because nobody's tracking it. It's just total free reign over the entire system, but not anymore. So very nice rule. We're happy to see it. And as we mentioned, the right people are very nervous about this. This is an attack on mail voting. How is it an attack? We literally just read it. It's just tracking the mail going out, tracking the mail coming in, validating the state's list. They can still put bad people on the list. Postal Service won't even touch it, won't even change it. Put your illegal aliens on the list. They're not going to remove them. It didn't say we're going to validate your list. Just said upload them to the portal. That's all. But they can't stand that. So they're going to sue, and we're going to have a lot of battling on this, no doubt. But very nice development. And it's going to be published officially on June 2nd in the Federal Register. Then public comments will come in for 30 days. And then we'll see how quickly they can get this implemented, because we need a list. We need to check it twice, find out who's allowed to vote or who should be reported to ICE. And we're going to keep our eye on this one. And Mark Elias is going to cry all weekend long about it, which means it's going to be a good one. So thank you for joining us and subscribing as we keep our focus on the election fraudsters. And join us when there's more updates on this one. All right, now, my friends, we've got a bad racist judge. We've had a lot of them this week. And here's another one from Alabama, I believe. Birmingham from Alabama. Another Alabama situation here. A racist judge from Alabama now suspended. You see her here on the right in her judicial attire, the black robe, looking regal and official. But on the left, this is how she appears on her Instagram account, apparently. And now some of this attitude from her Insta has been discovered being translated into her office, just like some other bad judges out there. And there was a 120-page complaint that was submitted against her. And it is riddled with problems. This judge is out of control. We'll hit the highlights, including where she said to a white clerk that you're all in favor of kissing that white ass, from an Alabama judge. Now, it's worse than that. She's also preventing her other staff from going and joining their sister dying of cancer, and the sister dies of cancer. And she's attacking attorneys. She's completely unhinged, which is why, of course, she's perfect to be a judge. So here's more on the story. We've got this Instagram video that was captured by Colin Rugg. Her name is Judge Yashiba Blanchard. She canceled hearings. She forced patients to remain in the hospital, many of them on the verge of death. And she says, I know that you like kissing that white ass, to one of her staff. So here's what she looks like on Instagram. All right. So this is official judge with a gavel. Look at me. I'm going to be ethical and not racist. This is what she looks like on Instagram. And here you can see down here at I am Yashiba Blanchard ESQ. This is what they do. This is a judge on a bench. So I don't know that there's anything unethical or illegal about that, but you're a judge and you should have a little bit of decorum and not do whatever the hell that was. So that's kind of, you can just get the vibe, okay, from the person watching those videos. Kind of like a Jasmine Crockett vibe. Like, I'm so hot, I'm so sexy, I am everybody's favorite individual on the planet, kind of an egomaniac just dripping out of her pores, which are porous. And that sets the context for what we're about to get into. Now, here is more from the New York Post. They say she made racial comments about a white clerk and then postponed critical hearings to walk her dogs because her dogs are more important than her courtroom. And that's exactly what I'm talking about in those videos. You can just sense it. Now, an Alabama judge has now been suspended after she was making racial remarks about a white clerk and postponing critical hearings. She's named Yashiba Blanchard. Dozens of allegations of incompetence, chaos, backlogs, one attorney begging for a hearing to go on as scheduled, saying, Judge, my client is literally going to die. Please hear this case. She allegedly also was consistently late to court, did not hear a single case related to involuntary commitments until 9 months into her term, left patients languishing in hospital mental wards, according to a new complaint filed by the Judicial Inquiry Commission. That's why it's 120 pages. And she's now off the bench. Outraged hospital staff were also reporting on canceled hearings, because she won't hear the case, making people sit in the hospital for an additional 2 weeks because they can't get a hearing. They're involuntarily committed. They want to get out, go to the hospital, get restored, have a mental breakdown. Can you let me out? No, I'll see you in 2 weeks. So I have to sit in the hospital. It's like jail. Now, the complaint is massive. 24 instances of hearings delayed or canceled. She's accused of also targeting the chief clerk called Amanda Reed. Amanda Reed is a white clerk, and they asked her a question. I'll show you from the complaint. And she says back to this white clerk, "Oh, I forgot. You all like kissing white ass." Here's another photo of her being all hot and judgy. So she's now been suspended indefinitely. That's her Instagram. I am Yeshiba Blanchard ESQ. And she shoved the white girl into a cubicle, threw her out of her office, and I've got the full story. So she faces 7 charges for violating multiple provisions of the Alabama Canons of Judicial Ethic, and she has been suspended indefinitely. Now, here is the background on her. This is over at Birmingham, Alabama Probate Court, Jefferson County, Alabama. And you're going to hear about Place 1. She's the Place 1 judge. She's got this litany of her background. I'm an amazing person. Probate judge number 2, who was like helping out and alleviating a bunch of the caseload, is this woman right here named Jamira Moore in probate 2. And this other woman called Jacqueline Knox all had to deal with this lady in multiple very problematic ways. And so here's the full complaint, 120 pages. So I just want to share the highlights with you here because it is a lot. The debauchery and degeneracy and the racism and cruelty to people who are in hospitals is just never ending. But she did a bunch of things. They got them all listed out here. Failed to hold timely hearings, failed to officially handle cases, making frequent and inappropriate requests. She wanted special judges appointed so that they could do her job for her. Improperly removed attorneys, violated black letter law, abused her power of contempt, filed unfounded bar complaints, filed baseless police reports against lawyers appearing in her court. She says, "I fear for my safety," filed police reports against the lawyers, ordered unwarranted forensic accountings of various estates, required clerks to issue letters for conservatorships, took judicial action in a case in which she was a previous lawyer. She exhibited a pattern and practice of bullying and retaliating against her staff. She allowed another court official to be bullied and harassed, failed to maintain competence in her administrative duties. And so now we're charging her with multiple violations. She got appointed not long ago, got elected 2024. Then on January 20th, she got sworn in. Now, havoc was created in the involuntary commitments proceedings. After she was elected, she was supposed to start her job soon. January 20th comes in, you're expected to start taking cases, and she didn't. So the Place 2 judge, who is this woman that we just shared, who's innocent in this whole thing, but is trying to help this lady, her name is Jamira, right here, she's the Place 2 judge. She says, she comes in and explains to her that you literally, lady, you literally cannot delay these involuntary commitment hearings, okay? These people have been involuntarily committed. They're on a drug, bender. They have gone a little bit crazy. They had a mental breakdown. So they're committed. They have a right to a hearing. We don't want to keep them. It's like going to jail, but you didn't commit a crime. So we want to make sure they have a hearing so you can hear them and release them. And it's literally not possible to delay these things because of state law. So from January until September, okay, this judge comes in, you expect, okay, maybe a week, she doesn't handle them. How do they work? Let me sit in with you for a week. Let me sit in with you for 2 weeks and figure it out. She didn't handle any of them from January until September, okay, 9 months, not a single hearing. The other judge handled them all. On September 19th, Judge Blanchard, this bad judge, entered an order that all involuntary commitments would be assigned evenly between the 2 probate judges. Okay, so now between her, and this is Blanchard, Yeshiba, but they call her Blanchard in this complaint. So she says, okay, fine. Now I'm going to split the cases. Then on September 30th, 9 months after she comes in, she takes her first docket, first case, which is why she's there. Judge Blanchard was still sometimes 30 to 45 minutes late. And on at least one occasion, there was everybody in the room, patients, social workers, psychiatrists, families, all of them were forced to wait there. And why was she late? She told her staff on one occasion that she was late to her docket because, quote, she had 3 dogs to walk, which again matches this vibe right here. Right? Know what I'm saying? Exactly. So she's out walking her dogs. Everybody else can just wait. On November 17th, Blanchard emailed the mental health coordinator about not evenly dividing these things. And the mental health coordinator had the place 2 judge hear more cases, right? This other lady is assigning them to place 2 because she actually did her job. These are vulnerable people. In many cases, these are seniors. These are people who had a drug, reaction. Something went wrong. They're not criminals. Then in November, she was again over an hour late. She heard 4 cases and then took a recess. After approximately 10 minutes, then her assistant came back into the courtroom and canceled the other 2 cases and said, sorry, you all are continued to December, 14 days later. So I'm not going to adjudicate your involuntary commitment and let you out. Go sit there for another 14 days. Now, the real reason she had to cancel these hearings is because she was running late to another meeting. And one of the 2 cases that was abruptly canceled involved a respondent that was supposed to be discharged from inpatient care and sent home. The hospital emailed her 3 times. They said, hey, she was not well. She came to the hospital. We got her fixed up. Now we have to let her out. Okay, the hospital, she's fine. We have to let her out. But I need your order to let this lady out. So please hear the case. Otherwise, then she's going to have emotional distress. Like this lady is going to be worse for being in jail, essentially, in a hospital for 2 more weeks. She has to stay there. They sent a second request. The hospital said to her that the effect of failing to hold the hearing means we house these people, and this prevents this lady from going home with her family for Thanksgiving. It increased costs. We got to pay for this. It creates emotional distress for her and her loved ones. Beyond this single case, you continue to cancel these things, and it's difficult to, they sent this to her, it's difficult to reconcile your actions with our shared responsibilities for due process and appropriative care. Then on November 3rd, after the 3rd request, the respondent was in bed crying and upset. She finally held the hearing and discharged the patient. Bunch of that goes on. Okay, that's one example. She then is trying to schedule cases on various days, says, I only want them scheduled on this day. This limitation, she's then changed kind of her schedule, meant she could only hear 6 cases on a singular docket and only twice a month, which meant a bunch of people couldn't get their cases adjudicated. She also sent emails saying, I take lunch from 1 p.m. to 2 p.m., so I don't want anything on my schedule. They say she also takes breaks lasting 15 to 20 minutes during the dockets and starts the dockets late anyways. So an hour lunch and a repeat breaks, and she works like 2 days a month and only does 6 hearings on those particular days. On average, Jefferson County Probate Court handles 15 commitment cases per week or 60 a month. So her limitation to hear only 12 per month means she would handle only 20% of these. And the other 20% would go to the other lady. So they ultimately assigned them to the other lady. And then, of course, that employee was not following this judge's order. This Judge Blanchard, Yeshiba, she said, split them down the middle, but she wasn't handling them. So the employee gave them to the other judge so that they comply with the law. So the whole thing was a mess. Extended hospital stays. She untimely held 4 probable cause hearings in which they were involuntarily detained. The presiding judge sent a letter to her saying, hey, we're getting a bunch of complaints about you. Hospital, staff, patients, many more people, hospital police. They're saying you have to hear these cases. And so that was just one issue. She met involuntarily. Then they had other due process rights violated. This is just one section of 120 pages. In total, from January 1 to May 21, 26, she heard 55 of her 62 cases. 7 cases assigned to her were also heard by a specially appointed probate judge. And so she was very, very underwater in terms of the total amount of cases that were being heard, and was screaming at everybody this entire time. So she failed to manage her cases, routinely continued cases, canceled dockets. You can see they have a whole list here of every specific case. So we'll fast forward through all of this, but May 27th, problem. April 14th, problem. June 23rd, problem. December 11th, problem. January 6th, problem. Goes on and on and on. Every one of these cases was some way, shape, or form a problem. Canceled without a future hearing date, canceled another one, and this is her docket. It's insane. Look at all these problems. I understand, like vomiting, like you're on the bench vomiting. Okay, I can't hear the case this afternoon because I don't have the mental capacity to do that. Not her. Canceled other hearings, no future date, canceled another one. What is she doing? It just goes on. It goes on and on and on for pages and pages and pages. And so we'll fast forward through all of this. You get the point, but they did their due diligence on this. Then, while all this was going on, she asked for special probate judges. So then she goes up to the 10th Circuit. She says, hi, I need more judges to help me with my work because I can't do it. The judge asked for Blanchard Yeshiba. She says, I would like a blanket order so I can get a local attorney to literally cover my judicial duties on days when I have election conferences for my other board. He said, no, we don't do blanket orders. We're not hiring somebody to come do your job for you. If you have a specific day where you need to go on a funeral or something, fine, I'll issue an order on this day. We appoint this person, pay them this amount of money. You got elected to do this. So then back and forth from her judicial assistant, what's the reason for the request? They say, well, because we need it. They responded saying that the Alabama Supreme Court requires a reason like incompetence, illness, or absence or something. She didn't care. She still wants this person. Then they come back with a scheduled absence. Okay, December 1, 2, 3, and 4. And it's a back and forth on this. They actually assign somebody to help this lady. Then it goes on and on. Presiding judge enters an order. Finally, some requests start getting denied. Said, while important, while I know you want somebody to do your job for you, community events, in my opinion, don't take priority over the managing of your docket, especially given the frequency of your recent judicial requests. Then Blanchard responded. She said, as part of my continuing efforts to reduce our backlog on cases that she's not working on, I have requested our judge appoint a special attorney for me. And despite my aggressive efforts to handle my backlog, I'm frustrated that you're not giving me another judge to actually do my job. All while she's collecting money from the state in a form of a salary. So then that whole section, we can move on. She also then starts attacking attorneys. So she's not handling cases, continuing them all, showing up late because she has to walk her dog, delaying everything, whole litany of cases that are problematic, then asks and demands for help to do her work for her. Then on the cases she actually does appear, she shreds these other lawyers. And she removes these attorneys from over 140 cases because she's just a lunatic. In some cases, Britain was appointed as a conservator, and she comes in and starts kicking them off. She says, you're off the case, and didn't issue any findings, didn't provide any notice, failed to hold a hearing on it. All of those required under law. She began directing her staff, kick these judges off the case. Why? No one has any idea. People are asking her why. This is all in 2025. Enters a bunch of orders. We're not even to the good stuff yet. They start filing motions back and forth. And then on her own, she's mad at them because they start fighting back. So then she issues an order to show cause for contempt. Why should I not hold you in contempt? They say the alleged conduct constituted constructive contempt and he had no notice. These lawyers are just getting ramrodded, okay, back and forth. After the contempt hearing, Judge Blanchard did not take any testimony or receive any evidence. She heard arguments from a lawyer. She stopped all hearings and said, I'm not going to get into your cases these days, the rest of her docket, because she's going to sanction these guys. Despite not hearing any testimony or receiving any evidence at all, she then enters a contempt order. She said, you have to comply with my orders on the 10 cases or I'm going to sanction you and find you, or I will arrest you. A lunatic. In one of the 10 cases, she was a lawyer on that prior case for the protected person. So following the contempt order, then he hands the cases over and they try to, get off the cases. Memorandums of understanding happen. Her bad faith refusal to acknowledge the efforts is an abuse of power, obviously and clearly. She distributed memoranda and it just goes on. Okay, so she's crazy. Then she files a bar complaint against this guy. In the bar complaint, the form says, what did they fail to do? What was the problem? But the judge then claims that there were ethical violations. She accused this lawyer of deliberately attempting to foster an atmosphere of intimidation, harassment, undermining my authority and the integrity of the court, encouraging clerks to disregard rules. She said that Britain was part of a group of attorneys who are participating in a malicious campaign to distribute misinformation and create a hostile work environment to make her look incompetent and to make her look incapable of doing her job, okay? So these lawyers, and lawyers talk, man, they are then probably talking amongst themselves, talking garbage on this judge who is clearly incompetent and just terrible. All these judges, oh, great, we got this judge. So they come in, judge, the law says you have to do these things. There's a timeline. These people are involuntarily committed. So you have to follow the rule. She's, are you back talking me? Are you undermining my authority? Are you creating misinformation campaign to undermine my credibility in my own courtroom? Files a bar complaint against them. Says that this conduct also goes back to this other guy called Holly, another attorney. She provided nothing to support these conclusions. They were based entirely on personal opinions and hearsay, except an email. That email came out from Yeshiba. She said, hey, lawyer, this is what she sent to this lawyer. The email says, good morning, Holly. I am in receipt of your email. Now, he probably sends a nice email that says, can I get you to do something? Please, you're the judge. First, I do not have to explain anything to you or anyone else about my attorney's fees, about the work contracted by Miss Person as to my office. And I've had enough of your insults, even with your alluding, which is not even spelled right. Oh my gosh. To me being a crook on the phone in front of my staff a week ago. She says, you need to check the internet while Googling your name. Rumor is you're, Y-O-U-R, you're the crook. Can't even spell. Believe me, your reputation is not good in Jefferson County or in the news. If the bullying continues, I will report you to the bar. And the judge says, I will notify my husband because this is personal. Forgetting the apostrophe. Now, you were out of line in the hearing yesterday and have been every time I speak with you. Mr. JD is privy to my attorney's fees and the work his cousin requested for my office to perform that. And Miss Somebody signed my contract in my presence and in the presence of my staff. You can take this email as a warning because I have had enough of you. Furthermore, get out of your feelings and honestly defend your 400 plus clients. Regards, the judge Yeshiva. And I guess this is from when she was a judge, maybe when she was not a judge. But that's her attitude, okay? So has poor grammar, can't even spell allude, or use the correct version of the word allude, like eluding the police versus alluding to a concept. Your, Y-O-U-R versus Y-O-U apostrophe R-E as a contraction for you are the crook. Ugh. So in response to that email, Holly, the attorney, questioned a $30,000 deposit that was in the account of attorney Blanchard's client when he became the temporary conservator. And he's like now looking at her work, saying, what happened here? So in response to the complaint, then this lawyer responds and says, this lady's a disaster. Fundamental deficiencies. And Judge Blanchard's complaint confused normal professional disagreement with unprofessional conduct. And on Monday, the state bar notified, we're not pursuing your bar complaint, Yeshiba, you lunatic. So then she ordered a forensic accounting of all of the cases. Okay, so 3 days after her bar complaint was dismissed, she goes bananas. She then launches a forensic accounting of all of these attorneys' cases, 146 cases that are in her courtroom. She says, you're all, now I'm like the IRS, I'm auditing all of your asses, and says the January 29th forensic accounting order was also pre-approved, any fees associated with the accounting to come out of the client's estates. So they got to pay for it. No petition, no one requested an accounting. She did not provide notice to anybody, to their families who would be paying for this. She just went in and started attacking these lawyers. My goodness. A lot of them had been discharged. Some of them were no longer active. So she just pulls a financial enema on all of them. They dismiss her bar complaint. So she says, I'm wrecking your whole firm. Now they got to go to every one of their clients and say, we have to do a forensic accounting. The judge is mad at me. Clients don't know. They got some insane judge who's acting on the case. They said, what do you mean? A forensic accounting? Have you been stealing money? Has my brother been stealing money? Has the estate manager, the people who are the beneficiaries of the estate, have they been stealing money? What's happening? She didn't raise any deficiencies. She didn't indicate anything about why this was happening. It was all retribution. They filed a petition seeking a writ of mandamus. They take it up. Whole thing is now challenged by these lawyers. Man, these lawyers went through hell with this lady. In response to the petition for contempt, then she claimed excusable neglect in that she had not seen the order. And the judge that was assigned to hear the case dismissed it. They appealed the dismissal to the Alabama Supreme Court. Then she accuses them of harassment. She got a phone call from another lady, a former employee of one of these lawyers' firms, about a letter. In the letter, man accused attorneys Britton and Holly of financially exploiting people. Talking about home addresses, and the letter was addressed to lawyers, not to the judge. And there were photographs at security checkpoints the same day the presiding judge met separately with Blanchard, met separately with Jefferson County Sheriff's Office. And she says, so she tells the judge, I don't trust these lawyers, Britton and Holly, and I don't want them in my courtroom. Then after learning about the photographs, there were photographs of them taken, it sounds like at the security checkpoints. So she takes photographs of these two and posts them at the checkpoints into the courtroom so that they can't come into the court like these are wanted criminals. So then the lawyers go and hire defense lawyers. They go, holy crap. And it just continues on. We're only at page 60. So then another attorney, bias or prejudice against attorney Lindsay Eastwood, another lawyer. State Bar again got a bar complaint from the judge, accused her of unprofessional conduct, said we got constant complaints from her staff about her unprofessional conduct. And why? Because this lawyer spread falsehoods and untruths or negativity about her to purposely damage her image, character, name, and damage her career as a judge. So again, all the lawyers are talking garbage about her because she's a garbage person. And a group of attorneys who are participating in a malicious campaign to collude and distribute disturbing misinformation and create a hostile environment. And they say this couldn't be further from the truth. According to several members of the staff, Eastwood has never, ever been rude or disrespectful to them at all. And while serving as the chair of the Bar Association board, Eastwood frequently communicated with them at several bar events and was an amazing person. Eastwood even donated money and volunteered for the judge's campaign. Wow. She's not going to do that again. Judge Blanchard also complained about contacting a retired judge. These lawyers, you get the point. They're all talking garbage about her now, and now she's now filing bar complaints and throwing them out of the courtroom. So same type of complaint as before. Now let's talk about the staff. Beginning when she took office in January 25 and continuing up to today, Judge Blanchard has consistently bullied and retaliated against her staff. The first day that she began working on the court, she called one employee into her office and asked the employee, "Do you like the chief clerk called Amanda Reed, the chief clerk of the court, who happens to be a white woman?" The employee responded that they did like Miss Reed, and yeah, she's fine. We have no issues with her. The judge told that employee, "Oh, I forgot you all like kissing white ass. I forgot you all like kissing white ass," is what she said. They got on Instagram. Less than 2 months after taking office, then Blanchard ordered certain employees who had been assigned to the division to go to a different division. You're in Birmingham, go to Bessemer. She did that with no warning, minimal notice. They were directed to go there in 2 days. She said additional staff was needed over there and just got rid of them. She said, "This request is made by me and get out of here." Now, just to be clear, this is such a violation. You can't say white ass, kissing white ass. That's not how that works. Other cases have said you're removed as a judge. This other case, Alabama Court Judicial Declaration, December 10th, 2021, Inree Blockton, said other judges who called an employee an Uncle Tom, you're gone. Another judge called someone else a fat B, you're gone. Calling an employee a heifer, you're gone, even if it's true. But it also evinces an irrational animus that Judge Blanchard held towards Miss Reed that would come to dominate her conduct and behavior towards Miss Reed, a white woman. As it was Judge Blanchard's first day, Miss Reed had not even had an opportunity to do anything to antagonize her. So the only logical conclusion here is that Blanchard was driven, the judge, Yeshiva, by a personal animus. She made false pretexts for moving them and threw them out. Now, moving the staff made no sense at all. Explaining how many cases were open, no necessary reason for the move. If anything, Bessemer was overstaffed. They had more people there. And Birmingham had far greater need for clerks. And she was just being abusive. She reopened the record room and assigned a clerk to sit in the room full time. I'm the judge now. The record room did have a full-time staff position, but you're going to go sit with the files. And man, I'd love to know what the races were of these people who got thrown out. Multiple people tried to explain the situation, but she said, "I don't care. A clerk is sitting in the file room." No one even came in there. The clerk had nothing to do all day. After several months of having very little to do, the clerk was retrained to do e-recording. Okay, I guess since the judge said you have to sit there, I guess do some filing. I know I'm a clerk. I handle people who come in and want to file something. I stamp their paper. Nope, you're in the record room. Judge said so. Miss Barber even made the request to the judge that the clerks go back to Birmingham because we need them. There was no legitimate reason, all detrimental. In fact, one example, this is gross. I think we're not quite there yet, but Judge Blanchard ordered employees to move, and there was an upcoming medical procedure. The clerk sent an email saying, "Judge, I have a medical appointment." The judge did not respond and said, "Too bad, you're going." Another clerk sent an email, this is the bad one, where the judge said, "You're moving, said, "Is there anything I could do to come back to Birmingham? Because my sister is dying of cancer." Okay, this is sick. The clerk liked to visit her sisters in the evening after work and assist with her daily needs. And commuting to Bessemer, which was 30 to 45 minutes longer through heavy traffic, made it difficult to go visit her sister, who's literally dying of cancer. The place 2 judge, the nice woman, expressed to the employee in person, "There's nothing I can do. Yeshiba is the presiding judge of the court. It's her rules." Judge Blanchard never responded to the email at all. Shortly thereafter, the clerk's sister died of cancer. The clerk was unable to make it to the hospital in time to say goodbye because she was stuck in traffic driving to the hospital from Bessemer, which is where Yeshiba sent her. 9 months later, she ordered the mental health coordinator to report to the other location. Her stated reason entirely made up. In reality, it was punishment and retaliation. And again, I'd like to know the ethnicity of these people. Now, as with other employees, she moved. Blanchard provided Mr. Newton with no notice, said, "Just pack your bags, you're gone." And that is the same pattern that we see in the remainder of this section. Because she refused to hear enough cases, Place 2 judge picked up the cases. And then she blamed Mr. Newton. Okay, the employee in the court is not following her order. Place 2 judge handled more than 50 cases per month, and Blanchard, the chief judge, would only handle 12. So the employee was stacking Place 2 to actually get these cases done because the law says they have to get done in this time. She says, and starts attacking Mr. Newton. "I've instructed you many times to do this. You're not doing it," and ordered him to report into her office. Then the next day, she was over an hour late for her docket, canceled a hearing for a patient who was about to be discharged. That patient could not then go home and spend time with her family. Then she starts screaming at everybody. Place 2 then sent an email to her saying, "Now I've been limited to 6 cases per day, but we have to hear these cases. These cases are piling up." Place 2 judge says, "I don't know what to do." Letters go back and forth, then throws Mr. Newton out, says, "You're out," ordering his workstation be disassembled immediately. Said take all his furniture out, confirms no intention of ever allowing him to work there. He had been working there for 2 decades. Same thing happened. She went after everybody. Then it goes back to the white clerk. Now watch. When Chief Clerk informed affected staff members that they were being, quote, transferred, Blanchard sent an email to Miss Reed disputing the characterization. In an email sent out to the white clerk, Blanchard stated, "Hey, this email is a follow-up email confirming you met with the staff chosen for support for Bessemer and made corrections as to your conversations about those being permanently transferred. You miscommunicated that they were being transferred permanently. They're there for support. It's temporary. And I have flexibility to move people around temporarily, but they're not ever coming back here." She made comments to multiple employees saying, "You're not coming back. I put you where I want you to be." Eventually, when it became clear that she would never allow them to return, they reached out to higher ups. Then she notified the chief clerk, Reed, and 3 other clerks, "You're also moving. This is formal notification that you're now moving." Then responded to other emails saying, "I've instructed my staff to include the chief clerk and all other staff to get out." Sent another email to Newton stating, "I am in receipt of your email. I've instructed them to move. They're going." Then in another email, the deputy probate judge sent an email to the 5 employees copying Blanchard. It stated, "Report to your assigned work location," which is in Bessemer. Now, there were competing instructions. The chief clerk, Reed, and the mental health coordinator reported to Birmingham. Their appointing authority said, "You have to go there." And then Blanchard lost it. "What are you doing here? I said you're going over there." Then the judge's assistant, Yeshiba's assistant, sent an email to Newton said, get into my courtroom. The judge was in the courtroom, deputy probate judge, bailiff, and others. She screamed at him, this is the second notice about your failure to go to where I assigned you. And it's going to result in suspension or termination. Said, I want you to sign this and get all your items out immediately. Mr. Newton, shout out to him, refused to sign it. Judge Blanchard took even more extreme steps to attack the chief clerk, Reed, white ass girl. On April 17th, Judge Blanchard sent an email to multiple parties, including her, the deputy probate judge, and others. And she said, clear out her office today. The email stated that Miss Reed should go to Bessemer. The email also directed the judge and the judicial assistant. She said, my new assistant, Mr. Lewis, would be moving into Miss Reed's office and take all of her furniture out and put it in the locker upstairs. And Miss Reed is now getting moved to a cubicle, the chief clerk of the court. Then Mr. Lewis sent an email to Reed and said, hey, sorry, white ass girl. The judge has requested that all furniture in your office to be removed and stored in a locker. Then Miss Reed was summoned back into the judge's chambers. Reed was in the middle of conducting a will docket, and the Blanchard judge ordered her to report immediately. That resulted in a delay of the hearing. At the meeting was Lewis, the guy who's getting her office, Yeshiba, the judge, and two other people. At the meeting, Yeshiba gave Reed a verbal warning for failing to vacate her office quickly enough. She said, what? I never got any boxes or moving materials. Judge said, I don't care. I'm going to get General Services to get you some boxes. Never did. Miss Reed said, well, how would I continue to do my work? She said, get a laptop. She said, well, I have sensitive materials. Like, I'm the clerk of the court. I can't have stuff in a cubicle. Said, well, all those are going to be locked in the jury room. And said, I'm going to submit an official IT ticket to have you move. She never did. So Miss Reed got her own ticket, submitted to IT. Had no moving materials or anything, moved all of her stuff to a new location in a cubicle. And directly behind the cubicle was the court bailiff, Mr. Dozier. So she doesn't feel safe working here. She went to her former office to print out the docket. And when Judge Blanchard discovered her there at her office to use the printer, brought her back in, made her sit on the couch next to the deputy probate judge and said, you didn't leave quickly enough. Crazy. So it goes on. Later that day, they also summoned the Reed back in, and now they're going to sanction her. Now you're getting disciplinary action. Hand delivered for insubordination. You refuse to report to Bessemer to handle operational support as you were told. That is insubordination. And now I'm going to fire you if you don't comply moving forward. And then a second notice came down. Go to the other location or we're firing you. Once again, she refused to sign it. This lady is nuts. So Ms. Reed provided a written response email copying all of the other Jefferson employees. The county attorney responded now to all and stated, I've reviewed this matter and all requests to initiate disciplinary actions come through me. We reviewed these requests. Disciplinary action will not lie where an employee is acting with lawful direction. She responded to the email and said, oh, county attorney, are you representing white ass girl? And if another authority is here, these are tasks that I have ordered. Then an hour later, the county attorney responded and said, my email, along with supporting authority, states the procedure for disciplinary actions against these people. This email does not reference day-to-day operations or assignments, and I, along with other members, represent Jefferson County. This includes potential appeals. Despite the written response by Ms. Reed on April 30th, and despite communication from the county attorney, Blanchard said another email, you have been reported to go over here. They respond back, Reed responds back, my appointing authority is the county manager, not you. Then the judge responds, I'm the chief, as chief clerk of probate, it's not within your purview to determine how this should function. So get over there. Verbally notified again, going to write you up again. County attorney responded to the email. and like, a little squeamish on it. The other 3 employees who were directed to go over there, all of them fear Blanchard, the judge, Yeshiba, will retaliate against them. Multiple meetings. Then she screams at everybody in Bessemer. Judge Blanchard told the staff, if anyone went over my head and talked to HR or anyone else, that's insubordination. And you're going to be disciplined or fired. If anyone tries to report me to HR, you better make sure that they themselves are clean. She goes in and screams at all the employees. Told the employees they might assume any complaints would remain confidential, but she says, people tell me, anytime you complain, it gets back to me. Saying she had the ultimate authority. I have no boss. I'm the queen of the castle, and whatever I say goes. And she also threatened to take away mileage reimbursements, warning people not to respond to speak with anybody outside of me, and is just wild. Then a subpoena came in. The commission issued a subpoena to the chief clerk to provide certain probate case files. So they say, let me see what's going on over there. They directed Reed to comply with the subpoena. It's mandatory, not discretionary. Then she learned that Reed had responded to the subpoena. Then she sent an email. She said, any tasks should be completed. Please advise that all assigned office work is performed first. Otherwise, you're deviating from your tasks. Less than 3 hours later, she sent the second email. What did you do with the subpoena? Now she's freaked out. They start copying the county attorney. 20 minutes later, she responded, I'm in total disagreement with you. You have been given a verbal warning, and you have outstanding assignments, and you're insubordinate. Then made up a bunch of complaints about them, areas of concern, is going to blame them for all the things, had revoked her badge access, and you can just see how bad this is. So now we're fighting over the files. Keeps yelling at her in multiple emails. Despite the obstacles that she placed in her way, she completed as much as she could. Keeps hounding her. Did you do this? Did you do this? Did you do this? Going to make her the scapegoat for all of her misconduct. Then says she's insubordinate. And so it goes on and on and on. They've got an entire timeline that chronicles everything that happened. Emails back and forth. Now she's scapegoating the white girl. Bunch of emails flying around. More emails. So long story short, she is incompetent and cruel. She willfully defied the rules, ignored the administrative orders, sent emails that declared that I'm the only person with authority over the entire court. And now the charges drop. Negligence in your judicial duties, violation of all these judicial canons, pattern and practice of failing to follow the law, violating those canons, exhibiting bias, violating those canons, conflict of interest, failing to disqualify herself, charge 6, charge 7, and all signed here by the Judicial Inquiry Commission. Damn, this lady probably should be in jail for some reason, but that's just awful. And I bet there is way more here than they could even include. And hopefully the investigation continues. I hope that county attorney continues to look into that. I hope those subpoenas are resulting in criminal charges for some abuse of office type of Alabama state level charge. And maybe the feds can pick up on this as well, because she's essentially, by neglecting to do her job, maintaining people's detention, which is in violation of their constitutional rights. The law says they're entitled to a hearing. She did not give them those hearings. And she was maybe even unlawfully imprisoning them. Maybe she was essentially, kidnapping them by failing to do her job. People sat in custody of the state for way longer than they should. And then she abused her office to basically attack other lawyers, abusing her position of power for ill gains. So I hope there was a lot more that comes from this. Her staff had to have their sisters die. White girl got racist comments made about her and then abused. And people were left to essentially die in hospitals. And some did. So sick situation. And this is, of course, who we're dealing with. I am Yeshiba Blanchard, ESQ. She's over on Instagram. And while all this is happening, this is her vibe. Wow, look how beautiful I am. AKA vote. And people in Alabama voted her in. And that's the end of the game, hopefully for her forever. And I hope there are more serious consequences that come. And she can't even spell and use proper grammar. So that is Yeshiba. She's suspended indefinitely. Hopefully they can get somebody in there who is actually competent. And we'll see what those subpoenas return once they're processed by the county attorney. And we'll keep our eye on this one. All right, my friends, it has been a lovely and a beautiful stream. Happy Friday. Thank you for joining us as we attended to some business today. If you're just getting here, we talked about some big victories over in the great redistricting battle that has been underway for quite some time. We've got the Republicans in the lead with a slew of votes that they have picked up in the red states. Alabama decision came down today. We had some fun talking about that one. Louisiana picked up a seat, and we got to see inside the legislative debates in Louisiana as the great redistricting war continues. Then we talked about the Postal Service and the new proposed rules that have now been released. Mark Elias very unhappy about those, calling those an attack on America. But we read through the rules, and they look good and reasonable and very not even controversial, but they'll sue because the last thing that they need is an election with some integrity in it. Then lastly, we talked about a lunatic judge who you see here, Yeshiba, who was cruel and like a little dictator in an Alabama court. She's now suspended indefinitely, but there's 120 pages of debauchery and maybe even criminality inside. And so now, my friends, it is time to hear from you. Thank you for joining us. Thank you for subscribing to our channel. If you haven't already done that, I hope your week was outstanding. And now let's see what you have to say. It's a beautiful day and a lovely Friday. Who is joining us? Muffin Rando, Donut Mind Me and John. Thank you for clipping for us on the day. Friends, thank you for some of these donos. And yeah, here's Trump. You're fired. You're suspended. You should be in jail. And she was collecting a paycheck that entire time as she was abusing her staff. Hey, Michelle. Hey, just checking. YouTube hasn't allowed me to comment for a few weeks now. Yeah, Michelle, we see you loud and clear. Thanks for the dono. And thanks for being a membo. I'll keep my eye out for you. And maybe drop something in the chat if you're still listening in. But yeah, loud and clear. 5x5. Got you coming in hot. Thank you for the dono, Michelle. Hopefully you have a beautiful weekend ahead. Hey, Tara Rayner, 36 months as a membo. That's 4 babies. Thank you for doing the math for us. Mom of 4 in real life and 2.5 grandkids. Amazing, Tara. What a lovely, beautiful family. My mom's excited about her grandbaby coming soon. July 2026, baby. Hey, Tara, thank you for that. Thanks for being here. And thanks for doing the math for me so I didn't have to get out a calculator. We appreciate you. Hey, Hook. Yeah, did you see the CIA agent arrested for $40 million worth of gold bars? $2 million in cash and 350 gold Rolexes in his house. Yeah, we were going to cover that, I think, on a members stream in the morning. And then we got sidetracked with the Supreme Court decisions and spent a lot more time on those. But I did see that. I have that queued up on my case watch list on the docket list. So pretty amazing. 40 million. Yeah, that's a lot. And apparently they were just like giving it to him and he lied about everything. He lied about his credentials and experience and he's a pilot and all the things. No, you're not. Wild, Hook. Thanks for flagging that for us. Maybe we'll come back on that one tomorrow. Alexandria Sheriff's Office. Wild. Tim Jake, hey, breaking. Yeah, we saw this news too. Another U.S. district judge said that the Kennedy Center progressions cannot proceed and issued an injunction. They were going to make a bunch of improvements, cannot be renamed without an act of Congress. Trump's name must come off the building and all official materials. That makes them so mad that his name is on anything. They hate it. But we'll see what happens and whether or not the DOJ appeals that or where that goes. But I did see that one just break. No Trump Kennedy Center. I'm sure RFK Kennedy doesn't care. Thank you, Tim Jake. Yeah, we may cover that on the follow-up in the aftermath. But it's just another judge who's just mad. Can't build a ballroom. Can't name a building. Can't do anything because they're the president. And so you need an act of Congress. And I think there's a lot more improvements that are supposed to be happening there on that one. Thank you, Tim Jake. Hey, Biltong is here, King of Biltong. You can get Biltong at BiltongUSA.com. You can use code Robert. When you go over there, you'll save 10% off and you'll get premium, real craftsmanship meat. Biltong, clean ingredients, all made in the U.S. and sold directly to your door. Look at that stuff right there. Get your meat. Hey, what's up, Bagel Boy? I hate to say this, but as a retired postal employee, I know how crooked the unions are to always tilt the vote for Democrats, just like the teachers' unions. Scary and criminal. Yeah, and I wonder whether or not you think this will improve the tilting that goes on. And you know, stuff gets lost in the mail all the time. So what if it's a couple of ballots from that one zip code where it's very red? You know, a little bit of this, a little bit of that. Who's going to know? No one's going to know. So thank you for that, man. Shout out to our postal service workers listening in on the show. We don't really know how the whole situation is working over there, but to me, these changes feel like pretty common sense changes and like not even controversial at all. But we know how that works for their side. They don't like anything that secures an election. We got some comments on X while the locals loads. Hey, what's going on? TJ King. The backup tracking of ballot mail should use blockchain tokens so some crooked dingbat like Crazy Eyes Griswold can't hack the serialized barcodes. Blockchain, yeah, man. Ensconce it in the chain. Well, yeah, so this would be, I think, under the federal level, right? So like Griswold, a state secretary wouldn't be able to go in and pervert the Federalist, which is kind of the point, I think. But yeah, blockchain too, another solution. Hey, B. Torn, this was before COVID set the standards for mail-in ballot. Between 2012 and 2018, 28.3 million mail-in ballots remain unaccounted for, according to data from the Federal Election Assistance Commission. That's a lot. Yeah, and I would imagine some of those are intentionally unaccounted for. Maybe not all of them, but probably a large portion of them. Or, you know, a substantial, statistically significant portion of them. Thank you, Neuro D, for linking up our locals. We have great members-only streams in the morning. Watchingthewatchers.locals.com is where you can come and join us. Or on YouTube, click the members-only button. And we'll see you tomorrow for our members-only Saturday show, which is always a good time. And so, friends, we'll pause here on the evening. Let me see. Locals has been a little bit quirky today. We got a couple of comments. Rick D. Governor signed the new map out of Louisiana. Man, amazing. So it's official. +1 in Louisiana. Nice. Reladella says Australia has similar mail voting, trackable and obvious mail-in vote, no drop boxes. We have 5-day in-person vote. You cannot get on the rolls without 3 forms of ID. Makes sense. What is it, fascism over there? You guys living in a dictatorship? Well, you were back during COVID, but at least you got your mail stuff figured out, right? Why is it so complicated? Why can't people get IDs? They can. They just don't want you to track those. Now, Reladella, voting in Australia is also compulsory. You can wreck your vote but will be fined if it isn't lodged if you don't have a reasonable excuse. To even get a mail-in vote, you have to have a good reason. Aging, disability, work away, in danger if your name goes on the voter rolls. Yeah, that's interesting. I'm not so sure I agree with the compulsory voting thing. If you don't have an interest in participating in voting, then don't. I actually don't want you to vote. It'd be nice if you cared. We have so many low IQ, low propensity voters who don't know anything about anything, can't even name the 3 branches of government or a single right in the Bill of Rights, don't even know what parties are in control. Going and voting? There should be a little bit of a filter there. Yeah, if you can't, I've got a lot of thoughts on voting. But Blue Jean Baby, what's up? Virginia has many more options. If the mail-in ballot issue gets resolved, we'll win the gerrymandering war. Dems cheated in the now defunct election with an insane number of mail-in ballots. Yeah, it's why they fight so hard for it. Because that's their methodology of exploiting the system. And I think I saw a comment from the Rubos. Let's see what else we got going on. Yeah, locals is a little bit quirky today. The Hook, thank you for that. The Rubos shared this. Trump's response to the Kennedy Center judge just dropped. He posted this. He said, shockingly, a judge appointed by Barack Hussein Obama, Christopher Cooper, ruled that the Kennedy Center, which was close to going to close in early July for renovations and construction and be transformed into a beautiful building, none of it would be allowed without closure. He has ruled the 36-member board that voted for this didn't have the right to do it. The Kennedy Center has lost over 30 years, hundreds of millions of dollars. I take great pride in taking over a losing institution and turning it into a winner. Unfortunately, Cooper, as a radical leftist, would rather see it die. I'm fixing up everything in D.C. and it's thriving. So therefore, based on the fact that radical left Democrats care more about opposing your favorite president and me than saving a dying center, we're going to be working with Congress to transfer this failing institution back. What happened here? So I'm never been a president. I have instructed the Department of Commerce to make all necessary arrangements with Congress to allow full and complete transfer of the institution. They can take responsibility over the Kennedy Center and its management. I don't want it anymore. You don't want me. I don't want you. Going back to Congress. That's from President Trump. And so that's interesting. Thank you, the Rubos, for sending that one in and for sharing the latest update on that. Yeah, locals is a little bit wonked out today. So you're not alone in the chat. It's just not really working over there. But all right, so friends, let us pause here on the evening. It's a lovely Friday. Hopefully you're doing something fun and exciting this weekend, or just relaxing, restoring, and rejuvenating. And Rick D's talking about the Canadians are now requiring breathalyzers on every single person they stop. Wow. All right. That's pretty interesting. Thank you, Rick D. So friends, once again, it has been a beautiful week. Thank you for joining us and for being here this evening. If you're on YouTube, Jim Tells You is going to have a stream tonight, so we'll send you over there. Otherwise, big thanks to our amazing mods and meme smiths. We got Donut Mind Me in the house. John is joining us. We got Muffin Rando. What's up to K Bean and to Carrie B? We got Neuro D, Janik, Dog Digger, Geegum Geegum, Elliot, Just Rhonda, all modding the fort down for us, keeping things nice and beautiful around here. And thank you for joining us. Thank you for watching. Thank you for liking the video on your way out of here. And have yourselves a great and beautiful weekend. Restore, rejuvenate, and return. Because in order to do this appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a great week, my friends. A beautiful weekend. We'll see you right back here on Monday. Bye-bye.
marching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chatting line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together